On Friday, 16 February, the International Court of Justice rejected the request from South Africa for the UN legal body to impose urgent measures to safeguard Rafah in the Gaza Strip. However, the ICJ stressed that Israel must respect earlier measures imposed late last month at the preliminary stage in a landmark genocide case. In January, the ICJ ordered Israel to take all measures to prevent genocide in Gaza. However, it fell short of granting South Africa its demand for ordering an immediate ceasefire. Jason Beckett, professor of international law at the American University in Cairo, who spoke upon the ICJ ruling on genocide in Gaza, puts the situation in the wider context of persistent neocolonialism.
The ICJ judgment it's a curious document as much for what it doesn't say as what it does say. But the conditions for awarding provisional measures is that the court must believe that there is a plausible argument that Israel is carrying out genocide. For some reason, they never actually say that in the judgment. They say, it's a very strange phrase, that the rights claimed by South Africa are plausible, which really makes no sense because the rights claimed by South Africa are the rights in the treaty. They are by themselves inherently plausible. That was never the question. The question was violation, but the court carefully skirt around it. On the question of a ceasefire, as I say, it's very difficult to speculate, because the court simply didn't say anything. So South Africa made 9 requests for provisional measures. And what the court said is, we are going to make measures that are different to those that South Africa requested. And then they said nothing about the measures that South Africa had requested, so they gave no reason for not implementing those measures, which included the call for an immediate ceasefire. The judgment is more or less exactly what everyone expected. So the plus side is that it at least implicitly holds that it's plausible that Israel is committing genocide. The downside is that the provisional orders demanded are essentially meaningless. So I think part of the difference is that Russia and Ukraine are separate states, and that it was clear that Russia was using force on the territory of another state. The position with Israel is much, much more complex, and I'm disappointed that the court didn't deal with it in at least some detail. The Israeli argument is essentially that it's beyond the court's powers to order a ceasefire, because that would deny Israel its right of self-defense. But it's worth remembering that Russia also claimed self-defense in its invasion of the Ukraine, and as you said, the court nonetheless demanded an immediate ceasefire. The question should be even more complicated, because in the advisory opinion on the separation wall, 2004, the court had actually held that Israel, as the occupying power, has no right of self-defense in the occupied territories. So I want to say something that's slightly off topic, and then I'll try to come back. So in an ideal world, South Africa would be charging Israel with war crimes and crimes against humanity. But the ICJ has no jurisdiction to hear those claims against Israel. So the only reason that South Africa is charging genocide is because it's the only convention that gives the court jurisdiction to rule on Israeli conduct. But if we think about the initial idea that we should be talking about war crimes and crimes against humanity, that would assume that we should be talking about the law of war, that we should be talking about international humanitarian law. And I don't see why that is the case. I don't understand. If Israel has no right to self-defense, then it has no right to use force, then what is going on can't be a war. And in my view, we should be framing this whole thing in a policing paradigm. We should be looking at Israel as the occupying power to use policing techniques to maintain order, not to use military techniques to decimate a people. So, people often draw a comparison between apartheid South Africa and what is happening in historic Palestine. And I think that this parallel is very, very accurate, that we have to see all of Palestine as a single administrative entity that is run on an apartheid basis. But, I'm just about old enough to remember the struggles against apartheid in South Africa. And I can't imagine what the reaction would have been if the government had carpet bombed Soweto. It would be seen instantly as the atrocity that it is. Yeah, the neocolonial critique, the neocolonial story has a strange relationship with Israel. Israel was and is the last genuinely colonial state. So Israel is a settler colony. It was founded in a way on a genocide. It was at the least founded on an ethnic cleansing. But it was also founded as an explicitly colonial project. So, for example, 1948, the year Israel is created, is a very interesting year in international law. It's also the year that the Universal Declaration of Human Rights is created, and it's also the year that apartheid is introduced in South Africa. The guy who's credited with drafting the Universal Declaration of Human Rights is a French lawyer called René Cassin. And Cassin was an ardent supporter of the Israeli project in Palestine, which he described explicitly as a colonial project. A chap called Jan Smuts, who's a South African politician, who actually wrote the preamble to the United Nations Charter, was also a very fervent advocate of the establishment of Israel on the colonial territory of Palestine. Jan Smuts was also the politician who introduced apartheid to South Africa. So it's important to see that in the eyes of the time, all of these things were compatible. The Universal Declaration of Human Rights, Israel, and apartheid were all parts of a single project. And that project was a colonial project. So we make this mistake or elision when we talk about the history of international law, and we present 1945 and the United Nations as this break point in the history of international law. But it's worth remembering that the United Nations was set up by the colonial powers, by Britain, by France, by the United States of America, by the then Soviet Union. The United Nations was a colonial project designed to govern a colonial world. Um, where there's an actual change, which is more interesting, is between the 1950s and the 1970s, where you have the movements of decolonization across Africa and Asia. And this is a very strange moment in the history of international law. It lasts for about 20 years. And the states, either peacefully or violently, fight their way out of direct colonial occupation. But they're left with a lot of colonial legacies. They're left with the state farm itself. They were only allowed to become independent if they agreed to become states. They were left with the colonial boundaries that were in place. They were left with the colonial legal systems and bureaucratic structures that were in place. More importantly, they were left with the colonial debts and the colonial contracts and the colonial treaties that were in place. And there was a fight over particularly the 1960s and 1970s for economic independence, for sovereignty over natural resources. And that fight was ultimately lost. So the former colonies were born without control over their borders, without control over the composition of their population, and without control over their own natural resources. And despite that, they tried to develop. And there are two separate stories to be told about the development period. I will tell each of them very briefly. One is a story of coups and assassinations, whereby across Africa and Asia, progressive leaders of former colonies were routinely deposed and or murdered at the command of what we would laughingly call the international community. Again, the United States of America, France, Britain, often Belgium. So the point that I want to make is in this period from the 1970s to 1983, we see the birth of a neo-colonial international law. And that international law still exists today. And it's a very specific international law, and we have to be very precise when we talk about it. As far as I'm aware, it only involves 4 institutions: the IMF, the World Bank, the World Trade Organization, and the system of international investment arbitration. The problem is that the policies that they coercively impose on states don't lead to development. And in fact, they actively preclude the possibility of development. So this is our neo-colonial world. Palestine's problem has always been the same, that they have resolute enemies and very poor friends. They either have friends like South Africa that are genuinely committed but relatively powerless, or they have false friends like the European Union who say they support a 2-state solution and trade with Israel on preferential terms for Israel compared to other non-EU states. So let me start slightly off topic and try to work my way back. So one thing I want to make clear is that I'm a very firm believer in Israel's right to exist. And I genuinely believe that the creation of a Jewish state was a form of just recompense for what happened in the Holocaust. What I disagree with is how that compensation was paid. That it was paid, and it says a lot about the mindset of the time, that it was paid using colonized land. And it seems to me that the most obvious and the most just solution that could have happened in the 1940s was to give either a part of Germany or Austria for the creation of a Jewish state, because it was, in essence, European Jewry that we were apologizing to. But instead, there were, if I remember rightly, 7 different options suggested, and all of them were on colonized land. There's this strange, for me, historical paradox that the Western European states, especially Germany, and the United States of America, and to a lesser extent Canada, feel very, very guilty about the Holocaust. But they feel absolutely no guilt about the Nakba. It's as if they don't want these two things to be related, or they simply won't engage with the founding of Israel, with the fact of the Nakba. And it seems to me that Palestine's only real hope is if we can somehow persuade European states to feel the same guilt about the Nakba that they feel about the Holocaust, because they bear the same responsibility. They caused it. I think the question of armed resistance is unfortunately moot. So there are a couple of things to say. One is that I think it's probably generally accepted that Palestinians do have a right of resistance. But that right of resistance is framed in terms of the law of war. So they can only exercise the right to resistance if they exclusively target military targets. And the simple truth, however unpalatable it may be, is Palestine cannot defeat Israel militarily. Yet Israel has one of the most advanced armies in the world, has one of the best funded armies in the world. So I think the resistance isn't a plausible way out. As you say, politics has so far failed terribly. International law is failing.